Hello, good morning, everybody. Welcome to the Small and Mighty Graduate webinars. This is the second in the series of webinars we're doing in partnership with Xero and ARU Peterborough. Today, we're talking all about the legal basics. We know this can be quite a big and scary topic, but we're doing a whistle-stop tour of everything you need to know as a small business. We've got Scott Steele with us today from ARU Peterborough, who's a lecturer in law. Hi, Scott, how are you?
I'm good, thanks very much. Thank you, everyone, for joining us. Very excited.
Thank you so much for spending this next hour with us. We're recording, so don't worry if you miss out on anything. You can always catch up. We'll send it directly to your email box. If you've got any questions following up, you can always email us at hello@smallbusinessbritain.uk. We'll have a little bit of time for questions at the end, so please do make use of the Q&A function. And we've got the lovely Catherine from ARU Peterborough with us as well, so she'll be responding to any questions in the chat as well. And finally, just say hello, let us know your business and where you are in the country. Thank you so much for joining us. I'm going to hand over to Scott and I'll see you at the end of the questions.
Thanks, Amber. Good morning, everyone. This is the legal basics small business. It is going to be sort of a whistle-stop tour of three various different sections. So what we're going to consider is legal structures of business, IP, and foundations of contract. And again, as Amber says, this is quite a scary topic of all three topics. It is quite a confusing topics, and that's why we have various infrastructures and businesses out there that can obviously help support small businesses, large businesses, and even medium businesses in sort of this context. So please don't feel scared to ask any questions at all. What I normally say to students and anyone that I meet is that no question is stupid. So please ask away. So I've included this slide. So that is my email. Please feel free to use it again. Obviously, you'll be disseminated various different documents from Small and Mighty later on. But please do get in touch at some point. So first of all, we're going to start with the organizations and business organizations and what they are and how they are. So the first slide is obviously unincorporated incorporated business organizations. So as you'll be aware that there is a number of business structures out there, which we'll get on in a later slide. But unincorporated businesses, not a lot of businesses now choose to go unincorporated, but we still have these around there. So there is a number of legal structures out there that does operate in sort of effect. Obviously, the downside of unincorporated businesses is that the risk of liability. If you're unincorporated, the people who own the business, run the business, manage the business are generally liable if there's any claims or anything that comes in, or any issues with that. We do find them. They're not very much, but again, sole traders are sort of operated as one of them unincorporated businesses. So we'll go through and we'll look at various different structures within that. But it is also that the liabilities, the governing laws around that also function from what is unincorporated and what is in incorporated business structures and organizations. Again, debt, liabilities, organization structures, rules and regulations, HMRC, in Companies House all factor into these various different logical organizations. So again, they are the legal right in their own. Incorporated organizations follow suit on that. They have the obligations, they have staffing issues, contracts, and leasing into their own name. So it is this logical solution that if you are incorporated, you don't then have to have anything in your name. There is the pros and cons to that, but again, the pros do at some point outweigh the negatives in consideration. Again, if you're leasing the property, the business goes bust, or there's an employment issue or anything like that, personal liability is then just removed. The business suffers. And we see this more and more. We've seen this in the pandemic. We've seen this in the economic crash in 2008, where a lot of incorporated businesses just then closed doors. They had liabilities, they had debt, they had issues, and there was a limited liability on directors and ownerships of sort of £1. So you pay £1 and that's it. the demographic and the issues of when it's unincorporated, obviously that the directors and the owners then bear all responsibility. But the next slide will help with that. So as you can see, unincorporated, we have sole trader, so the person, John Smith. We have partnerships, which are still very much in there. You do generally get that if it's a partnership, you do have limited liability of directors. So you can set that up as sort of a business structure, so that then if something happens with the partnership, then each partner has to pay a limited liability amount, which is agreed previously and is set up within the accounts, the business structure, and the organization. When it comes to the incorporated, we can see that there's 3 separate points. So we have the private limited company, we have the public limited company, we have the limited liability company. In my background, a lot of companies generally, when setting up businesses, when they set it up, do go to limited liabilities or private limited companies to go along the lines of that, simply for the liability issue should anything happen or occur. But again, this is very much personal choice. We can see, obviously, Tesco and a lot of the large companies are public limited companies, but again, they're the ones who have got the £1 billion, the insurance policies, the extra expense that small, medium businesses really can't afford in sort of today's society or into the business world. There is a level of protection. There is a level of protection with all of them. Insurance policies are absolutely fantastic. I don't say that because a lot of insurance policies are large, they are expensive. And when when businesses are starting up, it is an expense that sort of you've got to then put in your you've got to then really put it in your pocket and then burden that cost in the initial term, unless obviously revenue is coming in, etc. So it is an understanding that these issues occur. And that's why sort of legal basics and having that understanding of what is required is necessary. So as we first put on sort of sole trader, they must comply with the general obligations of business and relation issues such as employment, health and safety, etc. So a sole trader for every intent and purpose is self-employed. They have the business most likely to be small, no limited size in the business. Sole traders could have a large turnover, and we see this a lot in the legal world, where we have legal consultants who will be, for example, a consultant solicitor. They will generally fall under a law firm, but they will take a larger percent of the revenue gain from their cases. But again, if they don't take any cases, they don't get paid. So sole traders are very useful within society. Within the business sector, we generally see that sole traders are the ones first to see if there's a thirst for their services or for their equipment, sales, etc. And this is it is a very undersized and recognized avenue. There's no regulation disclosure of public accountability, which again is good for sole traders. They don't want to have to then publish accounts, etc. This is when we get into the more issues when it comes to the incorporated business structures. So partnerships, again, as we touched upon there, there's no really need to go further into that. So general partnerships as an unincorporated association with no legal existence. Again, there is a number of different partnerships that you can have. It's very difficult to sort of let one stand out there and sort of say this is the correct purpose. And by all means, this is not the ethos of this sort of PowerPoint to say this is the correct business structure. One business works for another and the other works for everyone else. It is simple as that. That's why, given sort of them options, trying to understand what the legal consequences, the liability issues, and what sort of the general requirements are, that is the key goals within this. So as you can see, again, we have another flow chart here. It really just sets out what sort of partnerships are, what their authority is, a third-party liability. and go through that. I'll not go through that. I can let you have a look at that at your own leisure. But it is quite a nice diagram to really see what, when, and how. And again, it's a visual topic, so it shows on the liability structure of sort of partnerships. So again, limited partnerships. We have the Partnerships Act. Please don't get scared when we mention law, that I've kept it to the bare minimum, simply because you're not lawyers. Although you will need to learn, you will need to understand them, you will reach for them. It's kind of this thing that a lot of people get scared of when you chuck an act out there. It's simply for demonstration purpose when you come to understand, or when you come to take that knowledge away from you. So again, an LLP is the body incorporated that is a legal entity. So you see a lot of LLPs around there that have their own name, their logo, their understanding, their organization, their address, their phone number. The point of an LLP is that we find these on Companies House continuously. That's where they're registered. You could be able to see their annual accounts, who their accountants are, their company registry, whether they're VAT, etc., etc. You'll also be able to have a look at the directors. So public companies, again, public companies they're out there massively. We generally find these within corporations or sort of the larger businesses. However, I've known a few small traders open public companies, but it's generally not. It's generally not for the first time. It's generally when businesses are getting more established. Liability for public companies are obviously open, and they regularly get sued for various different things. For if you think of Tesco's, if you think of product liability or staffing issues. They've got to register in exactly the same way. They've got a statutory minimum allocation of share allocation of around about £50,000. So again, when it comes to small businesses, we generally don't see small businesses open with a capital of £50,000, and generally go for public companies in the first instance. We generally see that slow, gradual build up, and to generally see how the directors want to take it, how the owners want to take it, and where they want to go for in that sort of place. Partnerships should have been in the previous slide. So limited partnerships we've already covered. Sorry, I went back there. Apologies. It wasn't the previous slide. So private companies, one of the final considerations is obviously is that they're quite rare private unlimited companies. This is where we see the liability issues coming into it, and we don't see them because there's better protection out there when we come to LLCs or private limited companies. So really, you generally have a liability by guarantee clause within an insurance policy or within along the lines of the company organization, which then protects shares or protects liability from owners, directors, etc. Like I say, it's very rare that you have sort of an unlimited company with a legal entity, but it does occur. But again, why would you set up a business where you could be completely liable for debts and incorporated? Sorry. So as you can see, another graphic here, registered companies. So you have the public companies liabilities, you have private companies. You can see the unlimited, limited by guarantee, and limited by shares. The majority of businesses that I've dealt with in the past are limited by guarantee, where if anything goes wrong with the organization, the business, that there's generally a pound. A lot of charities now have moved to limited by guarantee, to where volunteer trustees, directors have to pay £1 if something happens with the charity, if the charity can't function or they need to go bankrupt. So it is a way to limit that liability. And I think in sort of today's economic approach through politics, geopolitics, business structures, banking rates, mortgages, etc., it is comforting to have that sort of liability, that limited liability aspect, to where that there's no house guarantee, there's no mortgages, and everything's placed within that business. That business is that entity, and therefore that business pays for that. Should anything happen, if it's prosperous, then absolutely fantastic. If it's in a negative downturn due to the economy, then all parties then are protected, and we're not sort of losing our houses or bank balance or anything along the lines of that, which is what kind of happened within 2008. So it's something to consider. Again, very much it. Obviously, I wouldn't be given any insurances or any way to say this is the best company for you. So I would reach out to a professional within sort of the bigger industry, whether it's a lawyer, whether it's an accountant. But it is worthwhile. Again, a lot of people are sort of clued up majorly on this. They've done a lot of research. But even if you are, I would say definitely reach out to someone. There is a lot of business structures that offer free information, advice, and some offer a sort of an hour free, various different out there. Not going to go through this. I thought that it would be good to add sort of basic terminology in a number of slides, just so that when I've mentioned a word, you don't have to Google it, as I do that regularly. And it's just one of them things that we do. But some basic terminology through what we've just discussed to see what, when, and how, really. So in summary, there's a number of business organizations. There's not one right for all. That's why we have these sort of different incorporated and unincorporated structures, through small traders to, from sole traders to limited liability to public liability, etc., etc. There's no right way. I couldn't give that assurance to say, get this is the perfect thing for all. Sometimes it's not. Sometimes sole traders operate absolutely fantastically. They don't get sued, they don't have any issues, and they work successfully for a number of years. My grandfather did that, and he was never sued. He had a very successful operating and forklifting business along the lines of trades where he subcontracted. So I mean, sometimes it works absolutely perfectly. Obviously, with all three the types, there is a number of legal obligations that you should follow. You will be able to find this on HMRC and Companies House, whether you're incorporated or not incorporated. All different situations have different scenarios to where you've got to report, you've got to use that sort of organization to then allow for that legal compliance. And all three have a minimal level of compliance, but various different structures have that different legal level of compliance. So it is worth checking that out to make sure that you're ticking all the boxes, that everything's being checked legally, and that the business and company that you're operating, that is functional legally in the black. So it's going nicely, it's going swimmingly, and that obviously accounts are then followed suit, etc. So moving quite quickly on to IP. So IP is quite a difficult subject for even the sort of final year law students to master's level law students. So I've deliberately kept this short, concise, from the extreme number of PowerPoint and slides that it could be, simply because it's really complex. We have these IP clinics, and I mean, ARU does have an IP clinic. So if you do need any information, advice, go on our website and you'll be able to see that. You can submit a number of inquiries. We have student engagement in this also. And we do have an IP barrister, solicitor, lawyer, who comes along and offers advice on that. So if you do have any IP issues, or even just general questions, please do reach out to ARU Peterborough. Go on our website, click on the link, have a look, do some research, and do come along. It would be absolutely fantastic to see you. So key principle of IP, trademarks, first of all. So registered trademarks are quite common. I mean, logos from designs to names, generally everyone has one of these. Even if your company's Scott Steel Planting, for example, I like gardening. It's that we're trademarking the business so that someone can't come along and say Scott Steel Planting Flowers, for example, is another business, and therefore that confusion persists, comes up, and causes issues within sort of cash flow and business hiring of business and sort of that promotion. So basically the trademark is obtaining exclusive rights for what you want to be your own. Like I said, if that's a logo, if that's for Scott Steel Planting, and that's for me having a beautiful picture of my garden, for example, then I want to protect that as my own. I want to know that when I'm growing my business, my company, that is going to be the key asset to that. That is what's going to sell my brand, what's going to sell me, what's really going to get them people ringing me up and saying, we want you to plant some flowers. So it's really important that we consider the registering side of a trademark. We will touch upon slightly on unregistered trademarks. Again, when starting up, the typical side of unregistered stuff to keep costs down is one of the most paramount points. I mean, when starting businesses, we don't want to be putting hundreds of thousands of pounds in unless it works. So this growth, this understanding is really necessary. How we do it and everything, we'll get on to that. Like I was saying, you can have unregistered trademarks. Generally seek that out. If you've got something that you've paid for, or if you designed a professional logo, or if you've put money into something, it's probably best to get that registered. But again, cost associated with patent attorneys, etc., is going to be more money than some businesses, some corporations could earn, and it might not just seem feasible. It's about that brand, it's about building that brand, and it's about the consequences, or if someone, for example, on Facebook takes it, moves it around, and how that brand will then develop in the future, really. So there is a number of technical aspects to trademarks. We'll get onto patents later, but again, from the designs, the unregistered designs, rights, even if it's unregistered, you do still have rights. You can say, I've used this for a number of years, I bought this, therefore this is mine. It is common. A lot of businesses and companies do this, but it's harder. If you have something unregistered, it's always harder to prove that it's yours, unless we start keeping accounts and we can show that we have that line. Brexit, didn't want to say this too much. Brexit confused everything to do with IP. It's still the same within the UK, but obviously the continuing unregistered designs within the European Union are difficult now because of the breakaway. Again, it's not really something that we would consider massively within sort of these slides, simply because the legal issues are continuing, they're still ongoing. Come to the IP clinic. I think that would be the best to do if you have some of these kind of issues. So copyright, hopefully you'll all be aware of copyright. Protects the expression of the work and generally behind the idea. Again, copyright arises automatically on creation. So the best thing I can say about this, and this happened a few years ago in practice, was that a small business copied and pasted a contract for their clients from Google. What they did do is they copied and pasted it from a large corporation, which I'll not mention. That corporate, within the contract, they didn't proofread it or anything, so there was general terms relating to this corporation. It was flagged up, and this incorporation then went to the individual, went to the small trader, and basically said, you need to stop using our materials. We've drafted this, we've designed this, we've paid X amount of money for this. It needs to stop, go away. Simultaneously in that, the company did something that was not unusual. But when they allowed them to stop, there was no legal, there was nothing. They actually provided them with a simplified contract that they needed. So it sometimes it works, but I would say keep away from copy and paste. You can have a look at ideas. You can have a look. A lot of companies and organizations, especially to deal with businesses and setting up, do offer a simple form of contract. Again, lawyers will draft sort of basic contracts that you can add with. It is a worthwhile investment, but again, it's that investment, it's that cost, and I completely understand on that. For copyright issues and along the lines of that, there is a database. The database generally benefits from everything that is included within copyright or what we wish to copyright. So it can be protected. Copyright can be protected by the structure of the database if the original work is within that setup. It benefits from copyright protection. So it is, like I say, it is quite a difficult area when it comes to copyright. If you're writing something and it's your own and you have taken ideas and concepts, then that's absolutely fine. You can use that when copy and paste, and then be very, very diligent when it comes to such. It's all along the lines of plagiarism, collusion, corruption. But keep an eye on it. Again, simultaneously, if you're writing something and someone takes that from Facebook, there might be a copyright infringement, and infringement happens pretty much every single day. It's whether then if that infringement then loses some kind of profit or money or rights. That's when we come to a bigger issue. So patents, tomatoes, it varies. So it's a form of property protection. The simple form of it is a form of property protection. Generally, when it comes to services, unless you're doing something a separate way or a different way to all your competitors, you potentially want to patent that sort of that way, that service. Very difficult to, because again, it's a variation. If you design something, for example, or if you create something, invent something, then very much so this is your bread and butter. This is what you want to do. And we see hundreds of thousands, if not millions, of patents submitted to the IPO or the EPO, which is the European version, every single day all around the world. Some of these are in conflict. Some of these are just general patents to protect various different things. And again, they very much depend on jurisdiction. We'll get a jurisdiction in a couple of slides, but jurisdiction is key. If you invent something, it's probably wise to then file a patent in every single jurisdiction so that it's protected. But again, this is costly. There is certain help from that. A lot of angel investors or a lot of businesses will guarantee that. But again, it's quite a difficult area to summarize within sort of a couple of slides. So if you invent something, I would definitely recommend that you get legal advice on sort of this kind of area. As you can see, there's just a UK patent application. It's a little bit blurry. You can find these on Google. I mean, you can go to the UK Patent Office and they will show you the various different new patents that they've arrived, that have submitted and that have been there. It's quite a basic form. It holds as much information as you want to put in. Obviously, the more in depth, the more information that you put in, the better. We don't have uncertainties. The law hates uncertainties, and generally this kind of area is there. So what I would say is when filing one of these, you can file one yourself. There's no legal obligation to have someone file it for you, but it's always best to have someone relook over that who generally could say, actually, what about this? You haven't mentioned this. So do be careful when sort of if you are considering sort of this area. So again, we've already touched upon that. Sorry, my keys are going backwards for some reason today. So ownership. So a patent is a live document. It is an organizational document that continues to be live. There are various different obligations that you need to do through that. So again, in the slide it says it's straightforward with the employees to invent something. Its ownership of that is generally the company. For example, if you have 5 employees, one employee then invents something, you would hope that within the employment agreement you would have something along the lines of that if you invent something within property time on property business, then therefore it's a sole proprietary property of X company. Yeah. So write and file a patent, again, we've already discussed this. There's nothing really much to do with that. You generally have to renew patents every sort of, I think it's 20 years, or they can be cancelled, they can be revoked, they can be rescinded. It's just to keep that there's a number of live issues out there, and that's what I mean by a patent is a legally living document. It can be adjusted, it can be amended, and it continues that protection. So as long as it's relevant. So it is something to look into if you require sort of such a document. Reaction of competitors. This is another major one when we're looking at filing a patent. Other competitors do get to acknowledge this, do get to see your inventions. And you might think, well, this is counterintuitive. What's the point of me registering something if my competitors can then go and copy it? Well, they can't copy it. They can do variations as long as as long as the component that you are patenting doesn't conflict. So if, for example, if you invent a new version of the wheel, they can't then go and have a slight variation because it would infringe on that patent. But again, it's a very complex area. There's a number of guidelines on that. I don't think they're written very well. When I read them, I can understand them after the 6th read. So again, this is sort of the lawyer territory or the IP clinic that we can sort of help with this. It is best just to have something looked over by sort of a legal professional within sort of this regards. As I said, it doesn't stop infringing. We have infringements listed every single day. Some of these for the slight components, some of these are for trade secrets, which we'll touch upon in one of the next slides. But again, it's a commercialized world, and we see this continuously. There's various different steps that you can take. Again, we'll not get too much into that because I don't think it's really necessary without jumping into litigation, and litigation is quite a scary subject. You can negotiation, opening the communications up to say, actually, you're doing this. I would say a good 50-50 are simple. Oh, we didn't realize. The other ones, they've just blatantly stole it. So do take that into consideration. But again, when it comes to this, an email, opening them communications before jumping in anything feet first or jumping into litigation or say I'm going to sue and stamping feet, etc. It's just not needed. Many a times I've sent an email and it's been resolved within sort of that trail of emails. So mechanics of registration. There's a basic stage. Really, you can go on the patent office, you can go on gov.uk and it will take you through step by step. The form has got a lot better. It used to be quite complex. You can now do it online. There's a number of steps that you can follow. Obviously, it's governed by the Patent Act 1977. There's an assessment stage, there's an understanding stage, there's a demonstration stage. and that we'll see what is protectable. Again, you can design a rocket, and if one component you wish to protect is in that, there's no point filing the patent for the rocket. It's that component, it's that piece of invention. And it's generally the smaller things, the smaller aspects that we want to protect, because again, there's a number of rockets, there's a number of cars that all generally look the same, but it's that one component that again is that commercial element, is that that's the money maker, that's what the business thrives upon. As we discussed, maintain patents. We'll go through this. We'll just dismiss this slide because we already went through it. 20-year basis. It's a renewal phase. It's a living document. You've got to keep on top of these things, otherwise someone could steal it. You'll find more of this information on gov.uk. Or again, IP Clinic. We can help with this. Trade secrets. We generally find these within larger corporations or those who have already patents. These are the sort of the secrets that, for example, if we use KFC or McDonald's, the burger sauce, the secret sauces, etc. There's a lot around this of how trade secrets are within society, but also we use trade secrets every single day. We have the products of them, but we don't know how to make them. We can hazard a good guess, but it's that one ingredient, or it's that structure, or it's the way something's built. It's along the lines of that. It's quite a difficult area to register a trade secret unless you can provide originality and a number of criteria within that. You can provide protection indefinitely though with trade secrets. So where a patent you have 20 years, you can just imagine if McDonald's burger sauce, for example, was only open for 20 years and then they'd have to quickly file for another patent. That would be really interesting, actually. But yeah, it comes along where technology or recipes or procedures or something along the lines of that is really classed as a trade secret. Territory, just a quick one on this. Obviously, if you're operating within the UK and Wales, you would generally have in the contract, which we'll get on to a later stage, that the territory is within the UK and Wales, and therefore you would apply to that first. Patent owners have to think generally carefully about the territory that they wish to register the patent in. Some jurisdictions are a lot easier to gain patents, but again, that might not protect you in the area or within the state, within the country that you wish to sell the patent, and therefore you may be infringement within the UK, for example, but you're registered in Luxembourg, which you don't have an issue with selling. The problem is your business is not in Luxembourg. So that's the kind of the considerations and issues that you need to do when obviously looking at territory to file, jurisdictions which you want to sell, in general protections as well. So quickly, just on trademarks, as I can see, sort of time's ticking on quite fast. Words, logos, everything that we've really touched upon before. It's really about the slogans. I mean, we can pretty much all remember an advert where they've sang a brilliant jingle and it's been stuck in our head for weeks. They're protected trademarks. That's what the understanding and demonstrations are. It is important to understand and demonstrate the what a trademark is and registering from each and other company. It's quite an easy thing to do. It's quite a difficult thing to get past and updated. But again, we can help with that. A lot of lawyers can then just help with that, no problem. It is a general term. And generally, a lot of people register trademarks every single day without issue. Again, we'll bypass that and we'll get back onto the other one. Please, like I said, do reach out or do go to our IP Clinic or speak to a lawyer if you have any issues when it comes to anything along the lines of this. So we'll now touch upon the basics of contract. I don't want to keep this too legally because, again, contracts are the bane of some people's lives. Some people absolutely love contracts, but it's worthwhile just sort of flicking through these to understand what a contract is, why a contract is important, what are the sort of the basics elements of a contract, and how we can protect ourselves as business owners, company directors, into not doing something that would potentially be illegal, or conflicts a bit, or whether we're just writing something on a piece of paper that's not legally enforceable. So essential elements: agreement, consideration, intention to create legal relations, compliance, capacity. Obviously, there's the offer and offer. We'll put the offer and agreement together as well. These are the basic sort of considerations that when we're looking at contract law and where we're looking at whether a contract is valid between two parties, whether it's in business to business or business to consumer, this is when we generally consider these elements to see, have they all been met, or is the contract void? Is it just a piece of paper with the letterhead contract? So we'll go through a few of these examples in how to form a contract, etc. So forming a contract, contracts are required to be made by deed, written, oral. Contracts required to be made in writing. Again, you can have oral contracts. The difficulty with oral contracts is it's one person against the other person. Contracts written, email, text, etc. Perfect. Contracts required to be evidenced in writing. So again, it's quite a stigmatism to say that we need them to be written. There's handshake agreements, which are what they are. Friends, colleagues, I agree you to give you a £5 tomorrow if you buy us a cup of coffee, or if you mow me grass, I'll pay you this, and there's no contract in there. It varies much from business to business. And I mean, if you believe your clientele is absolutely fine with that, or if you're cutting someone's grass, it's 20 acres, you're asking for £1,000, you cut the grass and they don't pay you because you've not done it right, then what can you rely on? Has that been a handshake agreement? And you can see the loss and you can see the issue within that. So I would recommend a basic form of contract for anything that we do. I think it's good practice. I think it's practical, and I think a sort of a contract is the way forward when it comes to any dispute. So we'll look at offers and sort of what is an offer, how is an offer. These are the sort of, you could say that these are not sort of services, but they do have sort of reflection within that. So an invitation to treat is not an offer, but it's capable of being accepted by another party. We have a number of cases within contract law with this, which I'll not bore you too much about, but it's about when we make that offer to how we accept that offer, or whether we're shown an object in a window, for example, to say, you can purchase this, but you need to come to us to make an offer. It's generally how the perception of the client or the seller or the proposed person who is buying something acts. If you put a Facebook post out to say you're going to be, you have these different things for sale, you're inviting someone to make an offer. So you're not then saying this is an offer there. I think that's probably the easiest way to say it, but I mean it is quite complex to understand. Well, once you've got it, it's there. Basically, whoever wants to buy your services must make the offer. So we can see here another couple of examples, which I'll let you read at your own leisure. You can see a general assumption: what is a request for information, what is information, what is an offer, but there's no acceptance. Acceptance we'll get onto a later stage, but it's basically when someone makes someone an offer, the other person accepts that offer, and then we move down the chain of contract into what we should have, or why we should have. As I've just said, acceptance must be unconditional. So basically, yes, I accept this offer. If not that, then we have an offer, we have a counter offer, and then we have acceptance. We generally get this. I mean, the best thing you can see this is sort of on eBay or Marketplace, or in the street. Just generally, if someone comes up and says, "I'll give you £500 for that car," and you say, "Actually, no, it's up for 750. We'll do it at 650." We can see that route, and we do that route every single day. It's quite a common occurrence. Communication of acceptance. You can say yes. You can have it in writing. You can send an email. You can send a letter. It varies on how your contracts are set up within that business. It is also good to have that written communication to say, yeah, I accept that offer. Again, verbal is perfectly well. Face to face to have them assertions. But again, can we then demonstrate legally or factually that we have sort of that agreement, that we have that acceptance within there? We'll whiz through the next few slides because again, if we have the foundations and we have the formalities of a contract, then when it comes to sort of the voidables and unenforceable contracts, it kind of dismisses that somewhat. So basically, a voidable unenforceable contract is any form of contract that we don't have the foundations to, as we've just discussed. So offer, acceptance, intentions to legally create arrangements, etc. That's it. We can see a number of voidable and unenforceable contracts. It all depends what the terms say. It all depends what you build into that contract to see whether it's reasonable, fair, just, or reasonable, and whether it's enforceable. So there's no inducement, there's no breach of statutory rights, etc. Estoppel is another important principle within contract law, which deals with obviously equality, etc. Essentially embodies the general idea that what you say to something or to someone or to another person, you take it by face value. If you then say something or there's a different form of inducement, or they rely on what you say, then estoppel comes into place. It's basically a stop list that if something's been said, you're getting a red shiny car and you get a shiny blue car. That's the question. I would obviously fall breach of contract, and you'd go various down the lines to that. Misrepresentation is a really important thing for businesses. It's really important to say that the statements that you make are legally binding. If you say you're going to cut the grass within an inch, you have to cut that grass within an inch, or you potentially will be causing some kind of misrepresentation. We'll not go into the three areas of misrepresentation, but there is negligent misrepresentation, which is the sort of the bad. But generally, them kind of misrepresentation we find within sort of the word to word, to what we say, to how we say. So it's always important that sort of statements are made in line with the terms of the contract, and that you don't try to induce anyone into that sale or to that obligations or flesh it out from that. It's all about the persuading of the parties, and that's where inducement comes into effect within misrepresentation. If you found a misrepresentation as well, the contract really can be breached. They can sue for damages, or just rescission of the contract, cancel it, rejection. Statutory rights you find under the Sales of Goods Act, but also in the Consumer Rights Act as well, which says sort of what the statutory rights are when it comes to misrepresentation and them kinds of understandings. I'm just going to fly through these because I do want to get to some questions. So frustration is another way to basically look at the contract if there's an issue. I'll let you read these next few slides before I get to the questions, because I'm eager to see what kind of questions you have, if any. Again, force majeure clauses. another construct that will generally be inserted in a clause on the back of the doctrine of frustration, which narrows the limits. It just allows that extra bit of protection for the termination of a contract if something occurs for an event that is out of the control of the company. Jurisdiction, one of the final ones, again, you'll generally see within terms of all contracts that all disputes are issued in accordance with the jurisdiction of England and Wales. That's simply that if you sell something in Scotland and you live in England and you have legal teams in England and you have support in England, someone tries to issue a claim in Scotland, you can then apply to the court to say, under the terms within the contract, both parties agreed when signed the contract to a jurisdiction of England and Wales. Therefore, they've issued in the wrong jurisdiction, which forces the claimant or defendant or whoever to then switch jurisdictions to the agreed contract. You'll find this in standard within generally all terms. It is the preferred area so that you're not getting sued or there's no issues of arbitration and mediation throughout the world, really. It is a common thing, and I would urge to obviously have that as an incorporated term. Again, basic terminology in there for you to read at your own leisure. Just in case no one's picked up on that, a various different term that I've said. So, I mean, in summary, we've touched upon an offer, we've touched upon acceptance, we've touched upon intention to create legal relations, we've looked at what's voidable or how it's voidable, misrepresentation, etc. It all is around how you build that contract. As long as the basic requirements are within that contract, you can have asteroid issues in there. If there's an asteroid, you can't go to work on Monday. I would love that in my contract. Unfortunately, I don't have that. But I mean, you can build whatever you want within your contract as long as you have the basic legal requirements. You can do whatever. That's sometimes really dangerous. If I had to advise any clients, I would say keep it clear, keep it concise, keep it to the point. There's no point having 50 pages because no one reads 50 pages. No one writes 50 pages. I don't like writing 50 pages. So it's really important to really keep clear, concise, certain. Definitely keep to them principles. And thank you very much for listening to this whistle-stop tour of these three quite advanced areas of law. And I'll take any questions. Thank you very much, Amber.
Oh, amazing. Thank you so much for that. That was super interesting. So much information packed in there. We have got quite a few questions, so I'll try and run through those. I did pop in the chat. If you have any more questions after the session, please just email us at hello@smallbusinessbritain.uk. We had the lovely Catherine in the chat sharing lots of links as well, so we will include that in the follow-up email along with the recording of today's session. Right, Scott, let's jump into the questions. Okay, so the first one is, if I was a sole trader for a long time and then changed to a limited company, what would happen if something happened in the time I was a sole trader but came up now? Would I be covered by being a limited company or not? That's a good question.
It's a really good question. So we'd look at sort of limitation periods when it comes to this. So depending on what limitation period you've got within contract or anything, it's generally, for example, within personal injury, it's 3 years or 3 years from the advancement of 18. Within contract, it can be 3 months. It varies within that, within statutory rights, of course. The switch, I've known quite a lot of people switch from sole traders to become limited companies. I would say the grace period is 6 months. But again, a lot of insurances do extend that to sort of the 3 year. We can pretty much guarantee with a certainty, unless it's personal injury or the person who's been injured or issued has not reached the age of 18 yet. We can pretty much within a degree of certainty say that a 3 year basis is a guarantee. I mean, employment's 3 months, personal injury again, 3 years of the advancement of 18. company and contractual disputes. It varies on commercial to corporate, but again, it's generally within 3 months. If you have an issue, you generally raise a claim within 3 months, or you kind of statute barred. But you can on that trade. I've known a lot of sole traders take out preventative insurance, which is actually smaller than anything else. It's I can't remember how much it was, but it sort of prevents any issues from coming to that. But effectively, once you're a limited company, it's limited liability, so it's that stronger event. But yeah, I hope that answers that question.
Thank you. Yeah. I've just seen a question in the chat. We are recording. It will be sent directly to your email address, so do keep an eye out for that. I know we've had lots and lots of information today, so you guys want to catch up. Okay, on the subject of limited companies, the next question is, you mentioned earlier that charities register also as a company limited by guarantee. I wanted to understand if I could register a CIO and attach that to my company that is already registered as a company limited by guarantee.
I don't know. Funnily enough, I don't know.
Love the honesty.
I can't see why not, but again, it's really important that you get correct legal advice from a practitioner on this. I mean, obviously, charities do it a slightly different way. Charities register as a charity, but also a company for VAT reasons, so that they can claim various different allowances and bursaries through the tax system, because obviously they employ a certain number of employees. So it benefits a charity to also be registered as a company. But no, I'm not quite sure on that. So I would recommend that you either reach out to a solicitor who offers sort of a now as free basis to act on that, or you can. There is a number of businesses communities that you can ask that will offer just free advice and will offer sort of that support for that kind of transaction that you want to do.
Yeah. Also, if you haven't heard of Digital Boost, they provide free mentoring sessions. I know you can get in contact with them, just go to their website, and they have legal experts, I believe. It's all free for businesses as well. So that's another great resource. Amazing. Right. Okay. Next question for you, Scott. I was a garden designer and hire another designer who is a sole trader to do design work for me. Who owns the copyright for the designs? When it is given to the client, what stops them from taking my design and using it without paying for it? And if my Lucy designs something for me, what gives me the right to use it? And what about promoting it on, say, social media? Who owns the copyright? Sorry, there's quite a lot jam packed into that question.
So again, funny enough, I've just done this recently. I've just purchased a design for an equestrian association, so it's quite logical. So when obviously when you're designing or when someone's requested the design product, you own that, because you haven't drawn it, you haven't designed it. So the person who is the designer owns that product until they sell that product. And it's just, if you think of it just like a house when it comes to that. So when you when you sell that product and someone obviously completes the contract, you can have various different things within that contract that says that although they own it, you can promote it to show the work you've done. It's generally from business to business. It's fine to do this as long as you give reference in Creed. So, for example, if the person who's just designed our logo for the association that I've just adopted, they have put on their website, excellent work, the work we've just done from us. They've put the logo on, they've registered it, they've put our name under it, linked to email address and website, etc. And that's absolutely fine, because again, I get accreditation through the association gets accreditation through what they've done, their followers who might not be my followers, and that sort of publication. But it's really to say what you want to incorporate in your terms. If you want that designed to last 20 years, then you can put that in your terms. It's to what the buyer agrees to within that. But obviously, what I would typically say, once there's sort of that acceptance and that intention to create legal arrangements and agreements, and once that consideration, so once they've paid you, I would be arguing from any means that then they're the owner of that design. But by all means, have a look at your terms, have a look at your agreements, and maybe incorporate to how you want to view that. If you want to design something and then sell it, and then it's no longer yours, but you want to be able to have something on your website to say, and this is what I've designed. I mean, that's perfectly understandable, and a lot of organizations and traders do that.
Cool. So if they haven't already got this in their terms, is this something they can incorporate now? Obviously, they're already in their business, already working with these people.
Yeah, so very much so. I mean, you can have a variation to the contract. It's not uncommon to then create a variation clause within a contract to say that obviously if there's anything that you want to add or there's anything new that you have an obligation and a right to vary the contract, you can add that into a contract. No problem. Obviously, you need to make the other party aware. You can't just slip it in, get them to sign it. There's obviously legal obligations that you need to do. But again, a lot of these things are sort of logical and every single day. And when it comes to contracts and when it comes to issues, it's always just best to just speak to them. Just literally drop them an email and just say, listen, after I sell you this product, obviously it's your product, it's your design, you've bought it from me. Thank you very much for doing that. Can I publish this as the work I've done? In addition to that, I will put your reference under, or I've done this work for Scott's Planting Company, an excellent design. Thank you very much for your business. And that does two things. It promotes them to your followers, it promotes you to your followers, but also you get their followers as well to show that you've done the design. So it's sort of that, it's sort of that old adage, that quid pro quo, and how you want to do that and how you conduct business and showing your skills to a sort of larger audience.
Amazing. Final question of the session. Catherine has helpfully answered it in the chat, but I wanted to ask it for everyone else's benefit. To use the TM mark on documentation, do you have to be registered? Do you have to have registered the TM before you can use the mark, or can you still use it as an unregistered trademark?
What did Kat say?
Kat said you can, but easier to enforce it if registered. And then she shared a very helpful link, which I can include in the follow-up.
Yeah. Yeah, I mean, perfectly right. I mean, it's always best to register it. And I mean, the pros of registering it is that it's protected. If unregistered, it's a nightmare when it comes to infringement, stealing, copyright, etc., etc. The list just goes on. Obviously, the negatives of protection is cost. And I think every sole trader, every small business to medium business to large business would always say the amount of cost affects a profit. And when we're starting up, profit is essential because we need to pay the mortgage, we need to pay bills, we need to pay the council tax. So we really need to understand that. And I mean, it's very difficult. And I know a lot of business supports, such as the company you said before, will offer sort of the general understanding. There is a lot of bursaries and grants out there as well. And sort of Small Business Britain is offering sort of these kind of educational PowerPoints and these modules as sort of that, to sort of give that a little bit more education above Google. Google's fantastic, but it has its limits. So it's really on how much you want to spend to be certain. Again, a lot of these issues can be resolved by an email, a stern letter from a solicitor, or a friend or company director or accountant or someone within our lives. So it's generally on how much you want to go. But I mean, in an ideal world, I would say get the contract perfect, get everything protected, get the insurance in place, and make sure that you are not solely liable for anything that could go wrong. That's how I operate. I don't want to lose a penny. I'm happy losing sleep, but I don't want to lose a penny. But I want to be protected in every single thing. I'm overcautious, but again, I'm a lawyer. I like being overcautious. I like making sure everything's certain. And it's just it's one of them sort of things. But again, the IP clinic would help can help offer the various different advice, and we've got an excellent advisor within that clinic. And again, it's sort of student focused, so students will come. They will bring the client to one of the rooms. One of the solicitors will be there, and they'll offer you that sort of advice on that background. And it's a growing service. So the more participation we have, obviously, the more that we can make sort of business cases for future. But yeah, I mean, we're not the only one. So please don't be pressured to come to us just because I'm here. But yeah, it's sort of a fantastic service. But we're all here to help.
Catherine or Scott, please could you share the link with us for that? I think it'll be really helpful. Do go to Scott and his team. They are absolutely amazing. Can I just ask you one more question? I've just seen it come in just while we're here. We'll spend one more minute on it. So Sinead has asked, I normally send my contracts and say you can accept the contract and terms by replying to this email. Is that binding? Aren't we beyond signing documents now?
I would completely agree. So yes, we've generally seen that there's a sort of rule within contract where there was a postal rule, which was a postal rule that you had to then send. If you send something to the post, when the time you send it, it would be legally agreement. We've now seen a swift, especially since the pandemic, from contracts that we can sign over email. The important thing is getting that acceptance. So it's getting that signature. It doesn't have to be a wet signature. It has to be an agreement. It has to be sort of their name. The best sort of advice I could say from that. So is yes, perfect. You can do everything by email. However, you've got to keep account. So when they reply, you've got to make sure that you keep it, and it's got to be kept for the entire length of the contract, plus generally 6 years, 7 years in certain circumstances. So you need some kind of large file storage online, or you need to print it out. So it's 6 and 2/3. If you print it out, you're still having paper. If you're having file storage, it's got to be that business protected. So it's going to cost that little bit more, because again, if you lose it, then, and it does happen. It does happen. I mean, my OneDrive has been down quite a lot, or Dropbox, or whatever file service we use. In addition to that, what kind of software you can use, I generally find, actually, I don't. Generally, Microsoft is kind of good, but Adobe is fine. It's how you get that signature. It's always best to get that signature and a typed name than just a typed name, because again, if they come back and say, well, we don't know, we didn't type our name, it was someone else. A signature is always good. They can sign it with the mouse, they can sign it on an iPad, they can sign it on a phone now. So that software is out there. It is really developing. But keep it safe, print it out if possible, and just back yourself up in every single way. Computer clouds are fantastic, but they all go down at some point.
Amazing. Thank you so much, Scott. I've actually really enjoyed today's session. You've managed to make legal sound slightly simple. Thank you everyone for joining and asking your questions. We'll be sending you the recording. For the Small and Mighty course, we know it's over, but we'll be still doing some graduate webinars for you guys. So we're still here to help and support you. Massive round of applause for Scott. Thank you so much. Have a good rest of your day, and we'll see you very soon. Bye, everyone.
Thanks, everyone.